Mavarchim. And if you'd like to step down, I would like to call upon our two keynote speakers for the opening session, Robert Volterra and Professor Marcelo Cohen. The opening session that will deal with the topic of boundaries and borders in international law. We have two very eminent speakers for this morning's session, and I'll just say a few sentences about biographies you can read on the online program, on the online schedule. I should have mentioned that, of course, the schedule is online. If there are updates, they go in every day. All the abstracts are online. The little pamphlets you have in your package are 95% correct, but there's some last-minute changes which you received from me on email, which didn't quite get into that pamphlet. One or two sessions changed room, one was cancelled, but you'll see plenty on the notice boards on each room. You'll find a list of sessions. Our two speakers this morning, and I'll introduce you both now, if it's okay with you, and then you can just follow each other. They will speak for approximately half an hour, give or take, a bit longer, and hopefully we'll have a little bit of time left for some Q&A afterwards. Our two speakers, Robert Volterra is one of the world's top public international law practitioners. He qualified as a barrister in Canada and as a solicitor advocate in England and Wales. He advises and represents governments, international organizations, and private clients in a wide range of contentious and even non-contentious, I didn't realize lawyers did that, on non-contentious public international law and international dispute resolution issues, including international humanitarian law, the laws of war, international criminal law, boundaries, territorial integrity, UNCLOS, international agreements, and as a whole, that's about a third of the list I got through, and the rest of the list you can see, but you can understand why he is such an appropriate person to have as one of our keynote speakers. He will be followed by Professor Marcelo Cohen, who is Professor of International Law at the Graduate Institute of International and Development Studies in Geneva, and member of the Institute de Droit International and its Secretary General since 2015. He is the counsel and advocate for a number of states in 4 continents, represented before the ICJ, the International Court of Justice, the ITLOS, and other international tribunals. He also acts as an international arbitrator and has been a rapporteur for the International Law Association and many other international organizations. And he nearly became the latest addition to the International Court of Justice on behalf of Latin America. I understand that Brazil just managed to get in there before Argentina, but it just shows what a high reputation and prestige he has. Each of them will speak on different aspects of international law, boundaries, border arbitration, and I welcome Robert Volterra to open.
Thank you very much. My thanks to the organizers and we just had, particularly all the people who really have put this on, some of whom have been mentioned. My great thanks to David, whom I've known for a number of years, for having invited me, but most particularly to David's tie, without which nothing would have been possible. I'm going to talk to you today about land boundaries and territory rather than sea. The sea has a separate regime. You'll know about it under the UNCLOS, generally the UNCLOS, and I'm not going to address that. I'm going to talk about land boundaries and territory. I'm going to present you with 3 ideas today. The first is the continuing relevance of boundaries and territory. Secondly, because of that, the importance and relevance of the international law related to titles, territory, and boundaries. And thirdly, some of the practical aspects of resolving boundary and territorial disputes based on that law, which remain relevant. The title of my presentation, I honestly cannot recall, but it made reference to the metaverse. And I stuck that in there because I thought it might make my presentation more appealing. Marcelo, whom I've known for years and admire and respect, has such a star quality draw. I thought everyone would be out having coffee and then just come in for his presentation. So I thought if I put in the word metaverse, I might get some interest. The reason I put it in there, though, seriously, was to turn our thoughts first of all to the fact that the world has changed, blah, blah, blah. We all know that. But one of the ways it's changed is because of technology and the way human beings interact with each other and the way societies, countries, governments, and so on interact with each other. So my starting premise when I began thinking about my presentation today was, to what extent has this altered form of human global interstate interaction and communication changed the relevance of territory, title to territory, boundaries, etc., and therefore the law? And I thought, what a good way to hang the hook on then this metaverse idea, which has captured so many people's attention and, like cryptocurrency, has captured many people's investments, unfortunately. And indeed, I came out with the view that the metaverse is a bit like cryptocurrency, and that it's what in some legal context is called a pyramid scheme. It's a Ponzi scheme. It's a big trick on people. I'm sorry for all the metaverse fans out there. I first came to this view quite a while ago when one of my client governments asked me to help it set up the world's first metaverse embassy. Real country, real embassy on the metaverse. So I had to deal with IT specialists and internet specialists, and I'm no good at internet and IT and so on. So I learned a lot about the metaverse. And it is a world beyond the physical. But essentially what I came to understand, and I did produce the world's first metaverse embassy, but nonetheless, it is a combination of gaming platform and sort of out-of-our gaming platform with a kind of stylized Amazon type sales platform. So there's sort of an otherworldly aspect and a real-worldly aspect. But each of those worldly aspects ultimately is grounded in reality, which means they're grounded in physical space, and therefore territory and boundaries are relevant. The physical space in which they are relevant is when you buy something. The idea is you can virtually walk into a shop on the metaverse. They sell Levi jeans or whatever, and you can buy them with your avatar kind of trying them out. And one version you could buy is for your avatar, so your avatar looks more attractive when you go to the metaverse discotheque on a Saturday night. And the other is you can have really sent to you and you can put on. But that latter part shows that the metaverse is really connected with reality and the world and territory, because someone needs to not just take your money, because maybe you could have crypto money, but they need to have physically something in a warehouse that they then send to you physically where you are. And that's ultimately what the metaverse is. It's just a nice little toy. And it's grounded in the physical. Because it's grounded in the physical, it's grounded in space, which means it takes up, in some ways, both technical and metaphorically, a physical space on the surface of the earth. Therefore, territory is relevant. So states remain relevant. They, even if they aren't doing it properly, they regulate the internet, they regulate the electricity that generates the internet, even they regulate the customs and regulation of transportation of the things you're going to buy on the metaverse, just as they do when you buy things from Amazon and its like. And so states remain relevant, and therefore boundaries, territory, and the locations of boundaries and territory, and which state controls them or non-state controls them remains entirely relevant. As a consequence of this, the law related to the identification of boundaries and the allocation of title to territory is as important as it has been for the last 500 or so years at the very least. And this is because of the interrelation of the concepts of territorial sovereignty and jurisdiction in international law. International law is the law that governs relationships between states. It includes things like war and peace and so on, but it includes things like treaties and title to territory and the identification of boundaries. There are many things other than states that are interested in boundaries, interested in control over territory and exercise of sovereignty and jurisdiction. But in international law and in the international relation community that exists between states, the 193 odd, depending how you count states, this is regulated by international law. Now, I recognize that I'm here with a group of scholars. I'm a pretend scholar at the University of London, but really I'm a practicing lawyer. But I recognize that there's many interesting ideas about what should be, what ought to be, what could be. The reality of the world is that states and the community of states operate and interact with each other under this thing called international law. So if you want to know how states decide which country has title to territory or where a boundary should go or does go, then you must reference public international law. And the reason this is important is because, as I said, of the interrelation of the concepts of territory, sovereignty, and jurisdiction in international law. These things are entirely interrelated because of the nature of the international community as it's been constructed, and as it has constructed its own law conceptually. Territory, of course, means a portion of the surface of the globe. And that's easy enough to identify. Sovereignty has two meanings. One is the sort of, if you want, the soul of a state or the existence of statehood. I'm speaking at a very sort of abstracted level, but it's also a reference to the exercise of state authority. So when someone says, I'm Canadian, Canada has sovereignty over the Arctic. Someone mentioned this in one of the sessions I had this morning, or a portion of the Arctic. That is a reference to Canada, which is a sovereign, a state, having the right under international law to exercise authority over part of the Arctic. And by exercising authority, it's exercising regulation within its jurisdiction, that is to say, within its recognized territory. And so the interrelationship of territory and state authority and jurisdiction and sovereignty, my territory is being infringed by the exercise of authority by a sovereign whose ability to do IT is obviously much more superior to mine. Should stay open.
Along the night.
Максим записав,
There we go. So I was saying that the three concepts of territory, sovereignty, and jurisdiction are interrelated, and therefore boundaries and territory and the titles of territory are important. Now, it's important to understand that in the community of nations, which decides that it is governed by international law, public international law, there are a number of rules that have been created about title to territory and identification of boundaries within that. And it is a legal regulation. It's not a sort of economic regulation. It's not a social regulation. It's not a consensus amongst all states about necessarily where a particular boundary should go per se, but it is a legalistic approach to the allocation of territory in the world. And this legalistic approach has been agreed by states, developed over the last few hundreds of years, and I'm going to talk a little bit about some of the specifics of it. But it is the legal regulation of a territorial-based, state-centric international order. And that's what we live in today. You may like it or not, you may challenge it or not, you may want to change it or not, but that is the world in which we live today. It is a legally regulated, territorially based, state-centric legal order. And there are implications that result from that. One might ask, why is it that it is a legally regulated system rather than just a power-based system, for example, a military might-based system? Well, to understand that, we need to know a little bit about the development of international law and the international law of boundaries. But essentially, if you step back from public international law per se, any legal system dislikes a vacuum or an empty space, because legal systems are all about stability in a practical sense. I mean, they're possibly informed by morality, possibly informed by ethics, possibly informed by self-interest, possibly informed by many things. But they're about stability within the community to which they apply. And the public international law of boundaries and title to territory developed and is what it is today as a result of a near obsessive concern of the international community of states that there be no instability about the identity of the states that have title to a particular territory or the location of a boundary. And why is that? Because history has taught the international community that uncertainty about the location of boundaries and title to territory leads to instability. Instability leads to conflict. And the greatest conflicts that the world has known, apart from religious-based ones, revolve around access to and control over resources, human, physical, or otherwise. The development of international law related to boundaries and title to territory has developed along with the international community and along with public international law generally. And it is a European construct, if you will. Again, you can like it or not like it, but it developed essentially out of the constant warfare in Europe from the end of the Middle Ages and Renaissance, and a number of scholars and legal practitioners trying to identify common legal principles that the different states in Europe, particularly Western Europe, recognized. And so they were trying to find common threads of agreement about legal norms amongst states. So that's really how public international law developed, and it spread around the world with the colonial era. And then as states decolonized, they essentially agreed that they wanted to be part of the club of states, and therefore they would apply the public international law of that club. And it's a very sort of modo grosso description of what happened. But the development of international law followed the history of essentially Western Europe and its society, both inside Europe and during the colonial era. And so there were a number of legal principles that developed over the years, starting a number of hundreds of years ago, to decide what state was entitled to what territory and therefore which boundaries would result. So for example, 500 years ago, there was a legal principle in international law called discovery. And a state that discovered new territory, empty territory, could claim it for its own. Now, the legal principle was very clear. Its practical application was very difficult because the Europeans went out and, in quotation marks, discovered all sorts of new lands that were new to them, that had people whom they did not recognize to be states, and therefore they considered the area to be empty. And that in itself is obviously a significantly contentious historical event. But nonetheless, the European countries amongst themselves agreed that their mere discovery of these lands would be sufficient to give them, in public international law, title to the territory. But as history continued to historical events continued, and as more European countries engaged in colonization and discovering for themselves new lands, they had to come up with new rules to deal with how they would allocate the territory that, as between themselves, they thought they had discovered. And I use discovery in quotation marks, of course, because people living there didn't think they were lost in the first place. And there were various rules that were developed and agreed implicitly amongst the European nations as to how they would allocate the territory that they had discovered between themselves. And there were various other sort of rules that allowed a country to get title to territory through conquest, through military conquest. Now, that has not been deemed to be legal since about the Second World War. But it used to be entirely legal for a country to acquire territory through aggressive armed conflict. It's no longer the case, but it used to be perfectly legal. And there are many other forms of development in the law. One of the most important developments in the law was the idea that really was crystallized in a case in the early part of the 20th century, an arbitration called the Island of Palmas case, which ruled that in every boundary dispute or title to territory dispute, there is something called a critical date. It's a very important concept in the international law of title to territory and boundary disputes. And the critical date in international law is the date on which the parties to a dispute over territory or boundary are deemed to have recognized that they had a dispute as between them. You can imagine this happens in everyday life as well. You may have two neighbors, each of which thinks a nice cherry tree that blossoms in the springtime is on their property and belongs to them. And they each think that's a lovely thing until one day they're out both admiring their tree, and one says, "Oh, do you like my tree?" And the other person says, "Oh, well, no, it's my tree." And at that point, they've learned that there's a dispute between themselves. Well, it's a simplistic description, but the same kind of analogy happens between states in relation to territory. Probably much less so in the 21st century, but certainly in the earlier centuries, this was quite frequent. And this is important, the critical date, for a particular reason. I've given a very high level and rapid review of a few of the legal principles applicable to the acquisition of title to territory, the determination of boundaries in international law. But the law is not that complex. Public international law related to title to territory and boundaries is not complex at all. Now, Marcelo and I would be very, very worried in the practicing aspect of our professional lives if that was the end of the story, because then no one would hire us as their lawyers in the International Court of Justice, for example, to sort out their problems. It's not the law that's complex. It's the necessary facts underlying the law that can be complex. And as lawyers, the evidence that's required to establish the facts that are applied to the law that give you the outcome. So if you want to think about it, the legal process, and this is the legal process, not the geographical, human anthropological, historical. The legal process is, what is the law of title to territory in this particular circumstance? It's X. What are the facts needed to establish as between, for example, the two countries claiming title to territory? Well, you need fact 1, fact 2, fact 3. All right. Then how do you establish those facts, either for negotiation purposes or before the International Court of Justice? You need to have evidence, you need to have documents, you need to have photographs, you need to have maps, you need to have all those sorts of things, which are evidence of facts which are applied to the law and give you the legal outcome of the title to territory or the identification of the location of the boundary. So the law in this particular context is not so difficult. The art is determining what are the facts needed to establish the title to territory as opposed to the other claiming state. And what evidence can you provide that will establish the facts that result in the allocation in international law definitively the title between two or more competing states. And it's that collection, management, analysis, presentation of the facts, which is the art of the international lawyer, either in negotiations or in adjudication, arbitration, some form of dispute resolution. That's the art of it. And it's an art, it's not a science. And it's a very complex art. You know, 30 years ago, 40 years ago, cases, for example, in the International Court of Justice between states arguing about which state had title to territory of an island or where the boundary lie, could have a handful of documents establishing 1 or 2 facts. They're very limited. Nowadays, there are tens of thousands of documents that get submitted in these cases. Tens of thousands of documents. The last International Court of Justice case, which is a boundary dispute, I was involved, we got our decision last year. There were thousands and thousands of documents. And managing what I've just described, managing identification of facts, collection, processing, analysis of evidence, managing thousands of evidence, cross-relating them, correlating them, presenting them, that is a very, very complex task. And for that task, we international law practitioners inevitably work with social scientists. We work with human and physical geographers, cartographers, historians, anthropologists, and their input as to the relevant evidence and relevant facts and so on can be absolutely critical and determinative of outcomes. And that's where the concept of the critical date becomes so important. Because in public international law, evidence after a critical date is much less relevant. Why? Because the state already knows it's in a dispute, so the presumption is that it's going to fabricate evidence. not necessarily in an evil way, but that everything it does will be done with the knowledge that it has a dispute and must prove its outcome. Now, evidence after a dispute arises can be relevant if the state contradicts its position. For example, if the state thinks it has title to territory over an island, but actually it makes a speech at the United Nations saying that it doesn't have territory over the island, then it later claims it back. That can be problematic. But the fact that once a state knows that there is a dispute over an island, that it goes and sets up a lighthouse there, that fact of setting up a lighthouse doesn't increase the evidence of facts of exercise of sovereignty over the territory. And there's a very interesting comparison that we have in this country, and I just read about it in the news today, and that's the construction of settlements. Now, without getting into an analysis of the valuations involved in there, it's clear that Israel and whatever the Palestinian Authority or Palestinian people, or however you want to define them, know that they have a dispute about territory, and they have known for a very long time. So the building of settlements would not add to the evidence and facts in support of Israel's claim to that territory. It wouldn't detract from it, but it wouldn't add to it. Not after Israel and the other entity, however you choose to define that entity, realize they have a dispute about that. Right? So it's value neutral as to the outcome of a determination of the dispute over disputed territories. All right? Now, I've said that all without giving any sort of views or opinions about the underlying context. I'm just using that as a relevant local example of how facts after a dispute has crystallized, as it said, don't add to the outcome of the dispute under public international law. So I'm going to finish with just one concept, and that is, what is the primary principle applicable in public international law in the 21st century related to title to territory and therefore identification of where boundary is? And it's called effective occupation. Effective occupation. I gave you some snapshots of different applicable principles over the years related to title to territory as the world developed and the states developed. But certainly for some considerable time, arguably at least from the start of the 20th century, the single most applicable legal principle currently in play is called effective occupation. That's how title to territory is determined. An effective occupation essentially is the occupation of territory by a state in a manner that is effective. So the occupation doesn't necessarily mean literally every inch having a citizen of the country standing on it every minute of the time. It means, if you think back to what I said at the very beginning, after the comment about David's tie, it's the exercise of sovereignty by a state. And the amount of exercise of sovereignty by a state, the exercise of jurisdiction within territory, depends on whether it's peripheral territory or core territory. It's all relative. So a far-flung island that's visited by a Coast Guard once every 3 months may have a sufficient exercise of authority by a state to constitute effective occupation, whereas if it was 20 miles from the capital city, and there was only ever any effective governance or regulation of any kind once every 3 months, well, that might be a reason to say that the other state that claims the territory might have a claim to effective occupation. Because what happens is claims to territory are always relative, usually between 2 states, but sometimes more states. And in international law, it's not necessarily the case that there has to be an absolute and outright title to territory. It's just a relative evaluation of which claim is better. as between the two or more states that are making claim to the territory. So quite often when two states are claiming title to territory and they're looking back through the archives to look at the various examples of their exercise of jurisdiction and sovereignty in the area. They may look at colonial records, post-colonial records. They may look at historical archives. They may look at anthropological evidence of movements of peoples or periodic nomadism and so on. They may look at all these sorts of things, and each will present an argument and say, this is why this territory belongs to me, because this is the legal standard, effective occupation. This is what the legal standard was through history. And here's all the facts that sustain our claim to that territory, supported by all this kind of evidence. And the other state will do exactly the same thing. And the trier of fact in a court or tribunal will have to evaluate whose evidence is better, whose facts are more persuasive, which are more recent, all these sorts of things. And what is true for the adjudication process is true also for, less formally, for negotiation. I've settled more boundary and territorial disputes through being part of negotiating teams for countries than in international courts and tribunals. It's much more frequently done to resolve them in that respect. And you might think, oh, you just get together with another state and it's a power politics, not military threat, but economic power politics imbalance. No. It always revolves around references to what is the law, what are the facts, what evidence do the states have. It's a negotiation, even if it's face-to-face, but it's not just a power politic imbalance. And I can say in the public domain, for example, I represented and participated in negotiations for Barbados against France in relation to Martinique, Guadeloupe, and their maritime and seabed dispute. We had 4 years of settled outcomes, perfectly fine. And no stage was there any power imbalance pressure being put. It was all revolving around identifying the law, identifying the facts, identifying the evidence, and having dialogue around them. So I'm going to stop there. Bang on 30 minutes by my watch, notwithstanding IT interference. I think they got upset when I did the metaverse, probably. And thank you very much for your time and attention. And now I hand you over to Marcelo.
Good afternoon, everyone. It's a great pleasure to be here. I would like to join other speakers to thank David and the association for this kind of invitation and the possibility I have to address some views from a legal perspective to this prestigious and interdisciplinary audience. I have to say that David mentioned a special election that occurred last year at the United Nations after the passing of a Brazilian judge of the International Court of Justice. And I have to say that apart the Brazilians and the P5, there was someone else who was very happy with that David. Because of this outcome, I can be here. The title of my presentation is Territorial Disputes, International Law and Adjudication, when the three stars may be aligned, with question mark or without question mark. I have the intention to address each of these three stars briefly. Robert has already developed the star of international law. And I also will try to put together a couple of them, that is to say, territorial disputes and international law, and territorial disputes and adjudication. Territorial disputes are probably as old as the first encounter of two different human communities. Human activities displayed in a given area, and despite of the progress of borderless activities the essential of human life still display an given area, more or less well defined. The problem, of course, is when the limits of these areas are ill-defined, not defined at all, or when someone is willing to modify them. And this is the situation in which we find territorial disputes. I will mention 7 different types of territorial disputes. I'm sure that we will discuss many of them during these days of the conference, and probably other, but from the legal perspective, I would like to mention 7 of these territorial disputes. The first one I mentioned, when the boundary exists, but there is a controversy about its location. This is the first situation. The second one is when there is no boundary at all, and one has to create a new boundary. A third category could be when instead of the need of drawing a line, we have to take a decision about who owns a given specific area. The typical example is the situation of islands. Their decision is who owns this specific area. My contention is that international law addresses all these 3 types of disputes in the same manner. The 4th and 5th examples of different types of territorial dispute I would like to mention are related to the creation of new states. Because if there is a new state, there are new boundaries. And here, from a legal perspective, you have also 2 different possibilities. One is when the fundamental principle of international law of the right of peoples to self-determination is applicable, and this is one of the main problems in international law, to determine who is the holder of this right to self-determination, and when, if this case is applicable, the people have the right to decide, together with their neighbors, the extent of this territory. But the 5th category is when a new state is created without the support of international law, and this is the typical situation of secession, that is to say, the separation of part of an existing state in order to create a new one, or in order to be incorporated to an existing another one. The 6th category I would like to mention is that of disputes as to the use of shared resources, typically rivers, but not only, aquifers, gas, oil, fisheries. And the 7th one is disputes concerning transboundary environmental harm. That is to say, activities that occur within a given territory of a state, having an adverse effect in the territory of the other. So these are different types of territorial disputes, and a crucial question, obviously, is what are the criteria to be taken in order to find a solution for this kind of conflicts? And we all know that arguments are of different nature. It can be moral arguments, it can be historical, political, religious, matters of security concerns, economic elements, human elements, and I would say last but not least, the law, legal arguments. More than 20 years ago, I wrote an article in response to another article whose title was "International Law is the Best Moral Answer to Territorial Disputes." And after 2 decades, I continue to think the same. So the legal argument is not just one among other that can be taken into account or disregarded. It's not on an equal footing with other arguments, because international law is the only possible common language that exists among nations. The question is how international law governs the acquisition and loss of territorial sovereignty, and Robert has already addressed many of these elements. Of course, I will not repeat this. What I would say is there is no general treaty like we have in different areas, such as, for instance, the United Nations Convention of the Law of the Sea, addressing all or nearly all of the situations concerning the law of the sea. We don't have such a multilateral convention describing what are the manners to settle territorial disputes. But there is a set of customary rules. Most of them have been addressed by Robert. I will not discuss them. I will just probably, because we need to have some versions, otherwise it will be boring. International law today puts more emphasis on the legal holding of territory than effective control or effective occupation. This is the relationship what in international law we call titles and in French effectivité or effectiveness if you prefer. So emphasis is put today, emphasis is put in legal titles instead of effectivité. Also, what is relevant for the settlement of territorial disputes in contemporary international law are the fundamental principles of international law. That is to say, the provision of the use of force, the respect for the territorial integrity of states, the right of peoples to self-determination, and the obligation to settle international disputes through peaceful means. As Robert also said, international law favors stability. With regard to borders, there is a rule that has been acknowledged by the International Court of Justice in many cases, which is the principle of stability and finality of boundaries. That is to say, if two states have agreed on the existence of a boundary, the idea is to have a permanent boundary. The idea is that not to challenge it at any time. Of course, it can be modified, but only with the agreement of the same states. That's what I mentioned, basically, that international law offers all solutions to border and territorial disputes. The answer to this is no. It is not possible because when there are no boundaries at all, when the situation is entirely new, think about the creation of India and Pakistan as two separate states. So where the boundary lies between these two new states, it's not a matter that could be answered at that time by the international law. Sometimes I have to say, since I'm speaking about the creation of new states, international law does provide for a given rule in this situation, and this is the rule that is known as uti possidetis juris, which was elaborated in Latin America at the time of the decolonization from Spain, and later on, 1 century and a half later, it was also applied in the African continent. I turn to the other stuff, which is adjudication. That is to say, to submit a dispute to arbitration or to judicial settlement, typically the International Court of Justice. This is an alternative to the direct settlement of the dispute by the parties concerned. And here, obviously, I have to say, in order to settle a territorial dispute through adjudication, you need an agreement. You also need an agreement if you settle the dispute through direct negotiations. In both cases, you need an agreement. In one case, you decide, the two parties decide on the merits of the case, but in the other case, they just decide how to settle the dispute, that is to say, using adjudication, that is to say, arbitration of the ICJ. But adjudication, as I said, depends on consent. And there are different manners, of course, to give this kind of consent before the ICJ. There is the possibility of unilateral declarations by which a given state recognizes the jurisdiction of the court only with regard to those other states having made exactly the same declaration. The problem with this is that many of these declarations contain reservations, and in particular, with regard to the question of border or territorial disputes. Not all of them, but most of them. The other possibility is in some compromissory clauses that you find in multilateral treaties or even bilateral treaties for the settlement of international disputes. And in Latin America, there is one such a treaty, the Pact of Bogotá, which has been used for different cases that came to the International Court of Justice. And of course, the third possibility is when two states having a territorial dispute, they agree to a special agreement to submit this specific question to the International Court of Justice. Adjudication has advantages and drawbacks. And the paradox is that I can say that the advantage is at the same time the inconvenience of this kind of settlement, because the parties to the dispute put this dispute in the hands of a third person or organ. That is to say, they lost control about the outcome of the settlement. This can be, as I said, an advantage and also an inconvenience. And the question is, when it is useful to resort to adjudication. And I would like to recall what someone who was a great specialist in international law and this kind of disputes, and also someone who appeared many times before the ICJ, Sir Eli Lauterbach, and he said, avoid litigation if possible. But sometimes it is not possible to avoid litigation. And when it is worth going to the ICJ or to an arbitral tribunal. The first situation I would say is when there is nothing to lose. Or if you want to put it otherwise, when you will be at least in the equal situation or better off, no matter what the outcome of the case will be before the ICJ or before an arbitral tribunal. There are many examples of that, and these cases obviously come to the court, in particular when the state, having a difficult situation with its neighbor, decide to go to the International Court of Justice. Just to mention some of the cases in which I was involved, many Costa Rica versus Nicaragua cases came to the ICJ because of this. So Costa Rica considered that given the actions of Nicaragua, no matter the outcome of the decision of the court, it would be better off. The second possibility is when a state or a government considers that the political objective can be achieved even if losing the case. I will give you one example. The Libya-Chad case, that was the time of Colonel Gaddafi, who occupied the northern part of Chad. It was an effective control, and it could have remained. probably for years. Obviously, Chad didn't have any possibility to expect the Libyans from this territory. But you may remember, those of you who are not so young, that at that time, this was a case that came to the ICJ, beginning of the 90s. Gaddafi was isolated at the international level. He wanted to present himself as someone respecting the international law, etc., etc. And then probably he didn't know how to get rid of this occupation, and he accepted to go to the ICJ, even knowing that he doesn't have any legal argument to be defended. Third possibility, even if the government is not willing to go to the ICJ, there are some political factors that may oblige this government to go and to litigate. The fourth possibility is when two governments are not willing to make concessions and they consider that keeping a dispute alive is detrimental to the international relations of the relevant states. So this is also the situation in which the governments consider that it is worth going to the International Court of Justice. And then there is also a problem with the public opinions of the different states. Even if the governments may agree on a kind of settlement, they may fear the reactions of the public opinion on the position of the opposition, and then instead of appearing as having made concessions, they put the matter on a third person organ, and then they will face with regard to their public opinions. I would like to mention in this regard the decision to go to the ICJ, a very nice recent example. It was the first time that two states having a territorial and maritime disputes, before going to the ICJ, conducted a referendum in both states in order to let the people decide whether the case would be submitted to the ICJ or not. And this was the case of the dispute between Guatemala and Belize. So there were two referenda, one in each country, and both peoples accepted the fact that these disputes should be submitted to the ICJ. Are there alternatives to adjudication, including third-party participation? That is to say, instead of going to the ICJ or instead of going to an arbitral tribunal, are there other alternatives, apart obviously the direct negotiation between the parties? There is one which has been recently used, and it is the request of advisory opinions to the International Court of Justice. The example I'm thinking about is the separation of the Chagos archipelago by the United Kingdom from Mauritius in 1965. So Mauritius was trying to obtain the restitution of the Chagos archipelago through different means. Negotiations, the UK said no. Mauritius was ready to go to the ICJ because both Mauritius and the UK had made the declaration of acceptance to the International Court of Justice I mentioned a moment ago. But suddenly the British government modified its reservation and it excluded from the acceptance of the jurisdiction of the court disputes with former members of the Commonwealth, because there was a reservation according to which if there is a dispute between two members of the Commonwealth, this would not be settled by the ICJ. Mauritius decided to withdraw from the Commonwealth in order to go to the ICJ, but the British government, clever, modified the declaration and said, and also with former members of the common. So Mauritius was still thinking about how to deal with the matter. Both parties both states are parties to the UNCLOS, the United Nations Convention on the Law of the Sea, and instituted arbitration proceedings with regard to the Chagos Marine Protected Area, with the idea of having the tribunal discussing also the territorial sovereignty issue, but the majority of the tribunal considered that it could only deal with matters covered by UNCLOS, that is to say, maritime questions and non-territorial sovereignty. And it was after all these attempts that Mauritius obtained a resolution from the General Assembly requesting the ICJ to render an advisory opinion in the context of decolonization, and the court, in a very favorable way to Mauritius, considered that the presence of the United Kingdom in the Chagos Archipelago is illegal, and that the British government must put an end to this illegal situation. There is another example which is interesting, is conciliation, which is not a well-known procedure. It's a procedure similar to arbitration, but the outcome by the Conciliation Commission is not binding, and this is the difference. And this is what Timor-Leste did with regard to Australia, with regard to the Maritime Commission. And since we are here in Eilat, and Taba is not far from here, there was an arbitration, as most of you, all of you probably know, between Egypt and Israel. That was the first time that both Egypt and Israel decided to submit a territorial boundary dispute through adjudication. And there was also the idea to settle the dispute through conciliation, but it didn't work. And finally, the arbitral tribunal decided that Taba is part of Egypt. So to conclude, in order to give you the possibility to raise questions to us, I believe, I strongly believe that there are two of these stars that must always be aligned: territorial disputes and international law. Territorial disputes and adjudication, as you can imagine, it's not always possible. So, as I mentioned, it may depend on the consent of the parties concerned, or also, if you consider that advisory opinions are a quasi-adjudication, as I mentioned, it depends on the will of the majority of the General Assembly. In matters that regard territories for which there is a special international concern, that is to say non-self-governing territories, as it was the case of Mauritius, or former mandates, or former trust territories. I always like to finish with an optimistic approach to things. And if you look at the 15 or 16 territorial disputes that came to the ICJ, practically all of them have been settled. That is to say, the decision of the ICJ have entirely been respected in contentious cases. Yeah? In arbitration, the situation is a little bit different. In general, it is. Decisions are respected, but there were some situations in which the arbitral award was challenged. I don't have time to refer to this. So, to finish, I hope that I gave you some insights in order for you to better find the star of international law in the sky of territorial disputes. Thank you very much.
Yes. Okay, we have 10 minutes, and probably depending on how long the answers are, would you like to take three questions together? Well, let's see how they go together. Anne, please, number one.
Thank you. Thank you so much for your fabulous presentation, both. I have a slightly sided question. You touched external boundaries of the state, and I would like to ask you about the mix between public and private law and what takes, and how you deal with things like land grabbing and enclaves. How do you deal with the notion of sovereignty when international corporations and private entities start to dig out little bits and pieces of territory, and this territory is no longer accountable for the people who live on the land, like in the case of land grabbing for crops or for mining or for concessions. So how do you, from the point of view of international law, deal with these side effects of private law, like when the states sign contracts with private companies and whole patches and whole stretches of land are handed over in this case?
I think an hour each, you should be able to answer that one.
Very quickly, this great question raises what Marcelo identified as a difference of views between us about effective occupation, but it's not really a difference of opinion, because the effective part of effective occupation has to it's under legal title, so that the effectiveness ties to the legal title. We're actually in agreement. But the reason this is relevant to your question is, in international law, with some exceptions, which we don't need to get into here, states are monoliths. They're single entities within their boundaries. If that single entity chooses in its own internal laws to allocate territory to anybody, that's its business, and public international law does not have a say. Now, there's some exceptions for things like possibly human rights, possibly indigenous rights, and so on. But that's the basic proposition from which you work. And there are examples of states that have given away parts of their territory to other states, for example, Hong Kong, Macau, and so on. So giving it to a private entity as opposed to another state is not illegal in international law per se. That's my sense.
If I understand well the question, so it is quite clear that here we are not in a situation of cession of territorial sovereignty. So the private companies that we refer exploiting natural resources, and these have consequences with regard to the population living in these areas, with regard to the environment, and so on and so forth. And for this, well, there are rules of international law with regard to the protection of human rights, with regard to the protection of the environment. And also there are means of adjudication in some cases, because these are the cases of investment arbitration, for instance. Here, the difference with the SJ is that you have one SJ, but you have many arbitral tribunals and investment arbitration. And it all depends on the composition of the arbitral tribunals that you will have decisions more favorable to the very idea of protection of human rights for environment than for an investment, or I would say, unfortunately, vice versa.
William Sullivan.
Yes. I just wanted to ask two questions, one for the first speaker, about the colonization of Africa and the treaties that were signed. Could you expatiate more? Then for the second speaker, I didn't hear you mention about ICJ judgment on Bakassi Peninsula, because Nigeria lost the territories. Instead of negotiation, they went for adjudication. So were you part of the process? And we also discovered that the peace agreement is not sustainable as of now as it is. Thank you.
Yeah, you referred to the Bakassi Peninsula. That was indeed was an entire dispute about the whole boundary between Cameroon and Nigeria. Are you from Nigeria? Yes. And the court decided in favor of Cameroon, I have to say. The problem was that there were about 100,000 Nigerians living in the Bakassi Peninsula. Yes. And the question would not refer how these people came there. That's another story. They have comparisons with others. But this is precisely an example of what I said. So the court put emphasis on who has title to the Bakassi Peninsula, Nigeria or Cameroon. Was more effective in considering that it was right. It doesn't mean that the international law of the ICJ doesn't care about the population living in the territory, because there was a commitment by Cameroon before the ICJ with regard to the treatment granted to the population of Nigeria, to the respect for vested rights, etc., etc., etc. It was difficult to implement, yes. But still, so there was a need of UN involvement for the execution of the judgment. And I believe that on the whole, this is a good example that at the end of the day, international law prevails. Probably to disagree with me. If you have been judged, that's voted against. That's it.
Thank you. But just very quickly, as a practicing public international lawyer, when I read the pleadings and so on of that case, it was a classic example of poor lawyering. It was a bunch of law professors who don't know how to plead. So they didn't communicate effectively to the International Court of Justice. Cameroon essentially wanted the offshore oil, so it wanted a better oil delimitation. Right? Nigeria more wanted the Bakassi Peninsula, and somehow you read their pleadings, they did not communicate that effectively. Neither set of lawyers communicated that effectively to the International Court of Justice. Because the reality is the International Court of Justice, we all venerate it, but it's not international. It's not actually a court, and it doesn't dispense justice. It's a fantastic tool. It's a fantastic tool devised by the international community, as Marcelo said, he didn't say this, but as Marcelo said, to allow states to have very difficult political disputes resolved in ways that they don't have to do directly themselves between the states. So it's a great political tool, but you need to communicate effectively as advocates to it. And the Nigerian team, with all respect, didn't, the Cameroon didn't. And so the court gave the wrong thing. You're nodding, you agree. So in terms of the gentleman's question to me, oh, yes, about Africa, pre-colonial treaties and so on. The truth is that there were the European powers, I'll call them, who were colonized most of Africa, and between themselves over 100, 150 years, they came up with various treaties and boundary arbitrations dealing with the territory that belonged to the people living there. And some of the outcomes, we all know this, that there are boundary lines driven, splitting peoples, cultures, religions. You know better than us, ecosystems, economic trading systems. It was a terrible thing in that respect. How this affects the modern situation of territory in Africa is twofold. As Marcelo quite rightly said, there is an anathema in international law to undo boundary agreements and boundary cases because of the instability this causes. And this seems generally to have applied in international law to pre-independence type agreements. Secondly, in Africa, the African Union itself expressly endorsed the Organization of African Unity, as it then was, specifically endorsed the principle that Marcelo very eloquently explained of UT possidetis, which developed in Latin America, that essentially means that the post-colonial entity gets the boundaries it had when it was a colony in the colonial structure. And it results in some gross unfairness and inequities and terrible outcomes sometimes. But that's my view on it. I don't know if you have a...
I disagree with one aspect. I still believe that the International Court of Justice is international. It's a court of justice. But I'm not naive. And I am perfectly aware, of course, that judges are subject to political pressure. Because at the end of the day, the court is composed by 15 human beings coming from 15 different countries. Sometimes former diplomats, central clerks, and they have their own ideas about international law, but I still believe that the ICJ fulfills its function as an independent judicial body. Sometimes it's in a better manner than in other, but I still believe there is a matter of
We only have time for one more question. I'm sure around lunch you'll be happy to continue discussion. From Asia, Sanjay Chaturvedi.
Thank you, Mr. Chairman. I hope I'm loud enough to be heard. My question relates to the edges and interfaces, and particularly the concept of effective occupation. If I were to imagine a case between boundless nature, and my example here is of Antarctica, and a territorialized humanity, how are we going to establish effective occupation in a polar environment, nature, boundless nature, like Antarctica? 80% of world's fresh water, and we know there are competing claims legally frozen in Article 4 of the Antarctic Treaty. So my question is that have we reached the limits of international law on the edges in the era of Anthropocene? And if that is so, is there anything in international law which would allow us to metamorphose territoriality into trusteeship? Thank you. Thank you, Mr. Chairman.
Thank you for your question. Indeed, Antarctica is a continent. Antarctica is land. There are ice floes, of course, but it's land. So it's different from the Arctic. And both the Arctic and the Antarctica have two different regimes. But I would say that fortunately, there is the Treaty of Antarctica, the Treaty of Washington, that, I don't think to say so, it's very appropriate, frees territorial claims. Antarctica is very appropriate, frees. So there are 7 states claiming territorial sovereignty, but since 1959, if I'm not mistaken, this treaty has functioned. Today, Antarctica has a very specific regime in which any country of the world willing to go and to just produce scientific research is able to do it. There is no possibility to exploit the natural resources in Antarctica. So I believe that this system is functioning. And at least if you have something that functions at international level, better not to touch it. And it's functioning well. So thinking about putting Antarctica under trusteeship, for instance, would be so complicated. So let's the Treaty of Antarctica functioning. That's my answer.
I would agree that there's a system and international law is functioning there, as Marcelo has described. If I take your question as perhaps being informed by a wish to have Antarctica somehow preserved or managed either for environmental protection or for the greater good of every human being and that sort of thing, then I would still echo what Marcelo says in the sense that public international law has the tools to do that if the international community wishes to do so. So if you look at the law, the Sea Convention, for example, the global community created something called the area, which is an area of the seabed that lies beyond national jurisdiction. It's in fact the greater part of the seabed. And without getting into the details of it, it's supposed to be managed on behalf of humanity by the United Nations and the UN body, and all states are able to participate in its exploration and exploitation, and a certain percentage of revenues generated from that eventually are supposed to go back to this UN body. So the United Nations, the public international has the tools to do the sort of things you would want. What is required is the political will of the countries involved, because not just the 7 countries there, but all the countries of the world could establish the sort of regime that you're envisaging. Public international law has the tools, but it's a question of the political, just like environmental protection. We're going to next have, was it COP29 or something? We just had COP28 in Cairo, whatever. And every time, there's a great deal of carbon expended by all these NGOs going and saying you shouldn't expend carbon. Okay, but then they're struggling towards reaching agreement on this and that and the other thing. But if Marcelo and I were so minded, and if we were instructed by 50% of the world's states each. He's a rational, reasonable person. I would agree with him. In about 30 minutes, we could draft this treaty that would be required to resolve these problems, and all of the states would bind us on. The reason there is no outcomes to the COPs that are any use at the moment is that it's part of a political process, which may go on for a very long time. The states don't want to do it. And the reason they're meeting at the COP is political, because they want to show their peoples that they're doing something, but they know that actually, from all the opinion polls, their peoples don't want them to do anything that will reduce their financial well-being by, I think this polls show most people in most countries would accept 2 to 3% drop in their incomes. Right? So the governments are doing what they know the people really want, and virtue posing so that their populations think they're doing something.